Well, thank you all for joining this afternoon session. I'm really excited to be joined here by Nate Herman, Senior Vice President of Policy at American Apparel and Footwear Association. Welcome, Nate. I'm also joined by Amanda Levitt, Customs and International Trade Attorney for Sandler Travis and Rosenberg. And finally, I'm joined with Cindy Dillyon, founder and senior trade auditor at Dillyon Trade LLC. Thank you all for joining me this afternoon. Great. So just to kind of give folks who are dialed in idea of what the format of this panel will be, we're going to go around the room here. Really excited to have an expert panel here with a lot of different perspectives on the U.S. regulatory landscape. And we are going to kind of round robin here and talk through some of the issues and priorities that we're seeing when it comes to supply chain due diligence on the U.S. side. So I'm going to start with a question for Nate. What do your members at American Apparel and Footwear Association currently see as some of the most difficult aspects of navigating the regulatory landscape around supply chains? Do you have any advice on kind of where to start for companies that are worried about, frankly, these increasingly stringent due diligence requirements?
First, thanks for having me here, and second, of course, you give me the hardest question right out of the gate. So there's difficulty from a number of angles and advice that we can give. So first, with the regulatory environment, the proliferation of regulations or proposed regulations that have to do with due diligence or forced labor or related issues, obviously has created sort of a myriad of a regulatory framework. And the biggest problem with that is that all the rules are different. And so there's no harmonization among what's happening at the US level versus what's happening in Canada versus what's happening in Europe versus what's happening at the state level in the United States. None of them match up. Everything that's being proposed or is in place is all different. And so that creates a lot of confusion of how to approach that. Second, from a company standpoint, is all these new regulations are requiring one fundamental thing that for companies to do, and companies in our industry have not really had to do until we've been talking about this issue, believe me, for almost 15 years now, but have not really been forced to do until more recently, is having traceability and transparency throughout their supply chain, all the way back to the raw material. For various reasons, our industry is a contract manufacturing industry for the most part, which means we don't even own the factory that makes the shoe or the shirt, much less the fabric or the leather that goes into those shoes and shirts, much less the yarns, much less the ginners, the traders, and going all the way back to the field or to the petroleum or wherever the source of materials came from originally. And so that is a huge undertaking. And that's where we run into a lot of people just sort of paralyzed because it's such a huge undertaking, from going where in some cases you were using an agent, so you didn't even know your first tier contractor that was making the shirt or shoe, to going now that you need to know every single material that goes into that shirt or shoe, all the way back to the raw material. And you have to have knowledge what's happening at each stage of the supply chain and try and affect change at each stage of the supply chain. And that is your responsibility. You could be held liable if you don't. And also, it's very difficult to achieve your sustainability goals or your product safety goals if you don't have that information, because the impacts on sustainability or chemicals can be introduced way up the supply chain. It's not happening necessarily at the factory that's making the shirt or the shoe. And so this whole idea that you need to know everything and have control over everything dirt to shirt can be overwhelming for members. And so this is where the advice comes in. And there's a number of ways you can approach this. You can approach this by looking at where the highest risk product lines, the highest risk materials that you might have, highest risk countries or regions that you're sourcing from, and sort of focus on that country or one or two product lines, and just try and get a better understanding of how you do this, so that you do have to do this for your entire supply chain, that you can learn, have all your learnings, and sort of overcome hopefully all the challenges, focusing just on a small part of your supply chain, hopefully get the kinks worked out, focus on the supply chain that's going to be the highest risk most immediately under all the regulations, and then spread out from there. There's also a lot of technologies that are out there that can help you do this, ways to, you'll be collecting a lot of data, ways to manage and review all that data, ways to sort of assess risk, help you figure out who are your sources for various materials throughout your supply chain. That's sort of the advice I give, is that don't try and do everything at once. Start small, but you have to have some urgency behind this. This is not something you can just do over a period of 5, 10, 15 years. This is something that you need to be doing over a period of 5, 10, 15 months. And so people need to understand that.
That's really great advice. And I could not agree more on the urgency. Amanda, I think it's great to have you here from a legal perspective. Anything you would add by way of general advice for companies that are really considering the U.S. regulatory landscape, how to navigate it? How can they get ahead of the game and really prepare themselves for what's coming?
Sure. So at this stage, the U.S. regulatory landscape around UFLPA is still being formed, but it's clear that we have political and regulatory concerns with China. And more importantly, I think for importers, it's also clear that many of China's neighbors are connected in the supply chain, and many detentions are of vendors that are in the neighborhood. So if you really want to reduce your risk and get ahead of the game, it's not just about leaving China anymore and thinking you've avoided the often discussed risk altogether, but also assessing the real risks of having part of your supply chain in that neighborhood. And if you don't have a good understanding of those suppliers and how the supply chain may flow through many countries, not just China, in the neighborhood. And also considering the current landscape, my advice is to have a closer relationship with your raw material suppliers. Many of the allegations and detentions we're seeing are based on CBP's perceived risks of certain tier 2 or 3 suppliers potentially being in the supply chain for a shipment, and not necessarily just on the perceived risk of a tier 1 supplier. And also, your tier 1 suppliers may have stellar systems in place, but tracing falls apart at the tier 2 level or much deeper in the supply chain. And your risk isn't strictly related to what's actually going on, but it's related to what the US government believes may be going on, and the possibility that it may be in your supply chain for that shipment is enough to disrupt your imports. So my advice is to consider nominating your tier 2 or even tier 3 suppliers, whether that be a fabric mill or a PVC supplier, because it not only gives you greater visibility going back, but it gives you leverage if you need it. Because if you nominate those suppliers and you can create agreements with provisions of their responsibilities in the event of a detention or even allegations in a rumor mill, that gives you greater protection, and you're essentially leaning into the realities of what we're seeing under this current landscape. And lastly, in my opinion, we've very recently seen inquiries by Congress on entities with potential risks for labor transfers. And we don't yet know how that will inform the secret target list. So it's important to consider that if you were to have a detention or an exclusion of merchandise for a risk of whether the labor is the forced labor issue, not just the materials, your response to customs is going to need to look different than just tracing the materials. So it's a different beast, and I think it's one to be prepared for.
Thank you so much for that, Amanda. That's
Pleasure.
great and sage advice. I want to turn to you now, Cindy. Can you talk to us a little bit about Dillyon Trade's role in this space? What are some of the lessons that importers would benefit from learning as they embark upon implementing a UFLPA compliance program?
Absolutely. And thank you, Marissa, for the invitation. I think one of the things we've been really trying to do is get the word out and providing education to the trade community and almost becoming a translator between people in the forced labor space and in the software space and the trade community, because we don't all necessarily speak the same language, and we need to start speaking the same language. I think one of the biggest lessons learned for importers is that this goes well beyond your tier one supplier. And you can't really get the job done unless you map your supply chain and then identify all of the players in a transaction. As Amanda said, not only raw material suppliers, but also people within the supply chain that are conducting a process or a service to transform those materials to the next stage of production, to intermediate materials, right? I think another big lesson is a lot of companies believe they can do this without the use of tools and software, whether that's software for mapping, whether that's software to conduct supplier due diligence. Unless you are a very small company with a very, vertically integrated supply chain, maybe then you can do it. But if you're a relatively large importer with complex manufacturing, you really can't do this without some software tools, and you likely need more than one. A lot of companies out there believe, let me just find a tool that is a one-stop shop that can just do everything I need. And a lot of times you need multiple tools, not only software, but you need human resources to get this job done. I really liked one of the comments Nate made. I almost tell clients, you need to walk before you can run. And, clients are just so overwhelmed by mapping their entire supply chain for everything that they import. And a lot of times that's just not feasible. And it's not an excuse to not do anything. Mapping something and doing some due diligence and getting this ball rolling is critical. So don't let the Herculean task prevent you from getting started. Get started. And if you're going to start, please start by conducting a risk assessment. Don't just decide, well, I'm going to go with this one supplier over here. I'm going to start mapping this guy. No, map the supplier, map the commodity that is of highest risk to your program, right? And that's something that importers have come to learn, that are really embracing and standing up these forced labor compliance and due diligence programs.
Thank you, Cindy. I want to dive a little bit deeper into the UFLPA and what enforcement to date has looked like. We can see from the UFLPA statistics dashboard that shipments originating from countries other than China have been detained in pretty high numbers. It's something that's come up a number of times over the course of our panels throughout this conference. Question for you, Nate, is this something you've seen among AAFA membership? And how does that, what implications does that have for UFLPA enforcement?
So the short answer is yes. So we have seen, while the majority, based on number of shipments detained in our industry, are still coming from China, it's only sort of a bare majority. Well over a third of the shipments detained to date, according to the dashboard, have been coming from Vietnam, and we've seen shipments detained from other countries in Southeast Asia, such as Cambodia, and South Asia, like Bangladesh. And we've even seen some shipments detained from Nicaragua, which sort of has surprised us. We haven't been able to figure out the source of that at all. So yes, this definitely drives home the fact that it's not just, oh, we can stop importing from China, which is in our industry easier said than done anyway, but that doesn't solve the problem. If you're sourcing from other countries, you have not avoided the problem just by sourcing from other countries. It is a broad issue because it goes back, in our case, to cotton, the raw material. And cotton, even though the United States is the second largest grower of cotton, the largest exporter of cotton in the world. Cotton is turned into yarn all over the world, is then turned into fabric all over the world. And so a lot of that material still comes from China and then goes into our supply chains in other countries. And so that makes it a lot more difficult. But I'm going to take the opportunity to sort of echo something Amanda said earlier. A lot of the issues that we're having and looking at the enforcement statistics is that there's very little transparency or due process, or any process at all for that matter, in the implementation of UFLPA. Things that should have happened that we included in the legislation, because obviously none of us want any sort of forced labor in our supply chains, and we definitely do not want anything to support what the Chinese Communist Party is doing to the Uyghurs in Xinjiang. But there are ways that there should be processes in place to ensure that that U.S. Customs Border Protection is targeting the bad actors, not the good actors. And if you look at that same enforcement dashboard that has all the statistics, you can see that the targeting by U.S. Customs is way off. That over almost 40% overall of the detentions that they've made to date, those shipments have subsequently been released because the importer has proven that there is no nexus with Xinjiang. And so these shipments are detained, held for 6, 8 weeks, 2, 3 months in some cases. In our industry, we're a seasonal industry. If you hold that shipment that we intended for summer and it's not released until the fall, that shipment is rendered worthless, even if we're able to get the shipment released. So this targeting is way off. There's another Reuters article a number of weeks ago about some testing that CBP is doing, where they've pulled targeted shipments that they believed had some sort of nexus with Xinjiang, and only 15% of those shipments came up in the testing as coming from Xinjiang. That means their targeting is way off. Further, while we know the countries where these shipments are being detained, the importer, when they have a shipment detained, are not told anything about why the shipment was detained. Was it the supplier? Was it the country? Was it the type of product? Was it a supplier way back in the supply chain? They have no idea why their shipment was detained. And then as a result, if they petitioned for release, they had to prove a negative. That's not the way the U.S. jurisprudence, U.S. due process should work. You are accused of something, the evidence that that leads to the reason that you're accused should be presented to you so you can refute that evidence, and that's not happening today. So there's significant problems with the process. We agree with the goals of UFLPA, but there are huge problems with how it's being implemented.
You actually perfectly teed up my next question, which continues on the theme of due process. This is a question for you, Amanda. Considering the recent ruling against CBP for violating an importer's right to due process, this was the U.S. Court of Appeals for the Federal Circuit case related to Royal Brush and the anti-dumping claims. How do you think this might affect future CBP detentions? Are there any implications for this precedent that's now been set with this case?
Yeah, honestly, I'm not hopeful that Royal Brush alone would affect future CBP detentions under UFLPA or WROs, just because the case dealt with a different law, that being the Enforcement Protective Act of 2015, or EPA. And many times when the court issues a decision against a government agency, it limits the scope. And if we know that the Forced Labor Enforcement Task Force and Customs are currently being criticized for not doing enough, why would they interpret this decision more broadly to change their own behavior? So I think somebody has got to go to court and cite Royal Brush in forced labor and say, under UFLPA, we have the same problem. And there is a much better chance of success at that now because of Royal Brush, but somebody has got to raise their hand and bring that claim.
That's a great point, Amanda, and thank you for sharing that. it's interesting because this really has been a big topic of conversation in, I will say, our circles, this group's, everyone on this call circle, about the implications of this case and whether it would have any implications for UFLPA enforcement. And I agree with you. I think there's a need to cite it in a UFLPA case for it to really have real kind of staying power by way of precedent. Cindy, I want to turn things over to you here and talk a little bit about your background in trade law. Curious whether you have seen or how you have seen existing trade law impact enforcement of forced labor regulations, such as the UFLPA. Anything you can talk about there based on your experiences.
Sure. It's really interesting. I'm a very data-centric person. For those of you who don't know my background, I'm a former customs auditor and, worked on targeting and worked on enforcement cases a lot. I think customs is, in a way, trying to get the bang for their buck in the enforcement of the UFLPA. And what I mean by that is there are a lot of laws that can be examined in compliance while conducting a forced labor due diligence review. So don't just think about a detention situation. Think about a forced labor audit. Think about a forced labor risk assessment being done by an import specialist for a center of excellence by regulatory audit, right? If customs comes in, please make sure your trade compliance house is in order, because they can hit on forced labor as well as anti-dumping and countervailing duty compliance, because we all know that there's a lot of transshipment that is going on, and that transshipment is really easily put to light in a forced labor review. So there's AD/CVD compliance, country of origin. Things can be misclassified, not telling us what it actually really is. Free trade agreement eligibility is also easy to examine in a forced labor context because you're really digging deep into a bill of material. So, I'm working a couple of cases now, for example, in, certain commodities where there are, AD/CVD, forced labor, tariff classification reviews, and valuation all going on at the same time. And so I think it's really important to keep that in mind as you really focus on standing up your forced labor programs to make sure your trade compliance house is in order as well. For those of you data junkies on the line, don't forget that AD/CVD cases have HTS codes on them that flag the potential risk of the good being subject to a case. I think customs can use a lot of those same flags for targeting for forced labor purposes. So that's what I would say, just, looking at the AD/CVD, the HTS, the free trade agreement, alongside the forced labor risks compliance.
Thank you, Cindy. And sort of a follow-up to that question, since you do have such experience in the audit space, could you perhaps give us an example of how a company might strengthen its internal control programs to ensure customs compliance? This can be either related to forced labor or otherwise.
Yeah, definitely. For those of you who use the words internal controls loosely, remember that they mean something and that there are 5 components to internal control, right? There's control environment, control activities, risk assessment, information and communication, and monitoring. If you're going to say you have an internal control program, all 5 components of internal control need to be present. I think it's really important to stand up the program methodically, to identify the risks and then determine what are the control activities that are necessary and to what degree they're necessary in order to manage and mitigate those risks. From an audit perspective, I know a lot of companies are really struggling with, do I really need to map everything? It's kind of like post-entry audit, right? A lot of companies will say, I do 100% post-entry audit. I don't believe that to be true. I don't believe any large importer can do 100% post-entry audit well. Those of you out there who disagree with me, that's fine. But it's something that, my understanding of, the level to which you audit. I think quality auditing, guys, is better than quantity auditing. And it's going to be the same here in the forced labor space. If you're going to do something, do it well. Put programs in place, put procedures in place, put the training in place, and do this holistically, keeping all 5 components of internal control in mind. And then at the end, set up a program and then not test, it's at. So when you go in and you have everything and everything's implemented and up and running, then you got to do that monitoring and test, right? To see whether or not your controls as designed are working. Because a lot of times you might need to tweak things a little here, a little there, a little more here, a little less there, in order to really have a strong system of internal control in any space, whether it be trade compliance or whether it be forced labor.
Thank you, Cindy. I want to zoom out a little bit here outside of just the UFLPA. The UFLPA tends to take center stage when we talk about the U.S. regulatory landscape around, supply chain due diligence for obvious reasons. But individual U.S. states have also begun to propose legislation around supply chain due diligence that have some pretty broad implications. The New York Fashion Act is one example of one that's been kind of bouncing around for a while now. It's been in discussion. Question for you, Nate. How have your members begun to think about state versus federal supply chain due diligence laws?
So good question, Marissa. And this is what we've been trying to tell our members, that you can't take a myopic view of the situation. Oh, we're just going to figure out how to comply with UFLPA and we're going to stop there. That this is all part of a larger effort, and then gets back to the whole idea of the need for traceability and transparency in your supply chain, because eventually you're going to be responsible, not just as it relates to forced labor in Xinjiang, but as relates to everything you do from a labor and environmental perspective. And so we're already starting to see that at the state level. The leading legislation right now in that space is something called the New York Fashion Act to shorthand. The legislation will not move this year, but there is a good chance it can move in New York State next year or be replicated in other states. We've already seen a lot of action on the environmental side in California. It wouldn't be a surprise that they would take up legislation like the New York Fashion Act. And this requires not only reporting on a wide variety of sustainability and social issues, including things like wages and other issues, but then requires you to demonstrate due diligence to meet certain targets that are in the legislation and show improvement. And then you can be held liable for not hitting those goals or hitting those targets. And so that brings the focus to a whole new level. It's somewhat similar, but definitely different enough than what's happening in Europe with Corporate Sustainability Due Diligence Directive. But we're going to see more of that happening at the state level, particularly in states like New York and California, that you can't ignore. That you can't say, oh, we're not going to sell in California anymore, or not sell in New York anymore. So what happens in New York and California essentially becomes national law because there's such important markets for brands. So you can't ignore that. And that's why you say you can't just focus on UFLPA, that this is part of a much larger issue. And so you need to be mapping your supply chains, creating traceability and transparency, and conducting the due diligence necessary throughout your supply chain.
Thank you, Nate. On that same through line of thinking more broadly outside of just UFLPA, some of these related both regulations and programs, most folks on this call are aware that CTPAT's trade compliance program expanded its requirements, and those went into effect on August 1st. Those requirements included the requirement to conduct risk-based mapping. Nate, I won't ask you to speak on behalf of all of your members, but has AAFA's membership had any thoughts or impact? Have they been impacted by the CTPAT trade compliance expanded requirements? How have you been thinking about navigating the space? Obviously, this is a voluntary program, but curious whether you've seen members experiencing benefits to participating, particularly in the context of UFLPA enforcement, and conducting that risk-based mapping before a detention were to occur. Any thoughts there?
That's a very good question, Marissa. The CTPAT, and it used to be called Customs Trade Partnership Against Terrorism. So that's what the acronym stands for. We use a lot of acronyms here in Washington, D.C. But it was created after September 11th to help find, explosive devices in cargo and prevent terrorists being shipped through cargo from entering the United States. So that's what it was originally designed for. And our members were some of the largest industries to go into the program. And we have many members who are at what used to be the highest level of CTPAT Tier 3. We have not traditionally seen a lot of benefits from the program. However, you're supposed to be a trusted trader. So your shipments are supposed to move through customs faster and move through the process faster. In our industry, because of free trade agreements and other issues, that has not happened. We're still seen to be subject to the same number of exams, same number of reviews, same number of CF-28s and 29s than if you weren't part of the program. So when they moved to make it more of a general trusted trader program and added forced labor and social compliance in general to it, and then create a new level, this CTPAT trade compliance level, a lot of our members were skeptical. What were the real benefits of this? However, with UFLPA, there have been some marginal benefits from this. Advanced warning before the shipment arrives that it's under review for detention. That has a few members who've gone into the CTPAT trade compliance have seen that benefit, and so they're able to get their paperwork together right away if they're going to challenge detention or turn that shipment around before it enters U.S. ports. That's been helpful. Efforts where you can store the detained shipment in alternative places. If you're just a general importer, you only can do that in a bonded warehouse. You have more options if you're CTPAT trade compliance. So there have been a few benefits that have been tangible, not huge benefits, but there have been a few noticeable benefits that the few that have reached this new level of CTPAT trade compliance, and we are talking about a few. There's maybe only a few dozen companies that have hit that point so far, that they've seen some benefit.
Thank you, Nathan. But one thing that I know has been kind of a recurring theme in government since the UFLPA went into effect is, how do some of these programs incentivize as opposed to penalize companies? So, how can we promote these responsible supply chains, this level of supply chain due diligence, and continue to do so, but not focus purely on penalizing as does the UFLPA. So it'll be interesting to see, whether the CTPAT trade compliance program continues to evolve, or if other similar incentive programs do emerge over the coming years. Amanda, I want to circle back to another interesting court case. I know we just talked about the Royal Brush case, but in another unprecedented case, a company is currently suing to be removed from the UFLPA entities list. What can you tell us about this case, kind of the merits of that case, and what implications it might have?
Yeah, so 9-Star and its subsidiaries are suing essentially to be removed from the UFLPA entity list. And they have a claim that the Forced Labor Enforcement Task Force had listed them in violation of the Administrative Procedures Act, and that their actions were arbitrary and capricious. And I think they can eventually prevail on that claim under the APA, but they had also, and the filing that's before us now is they had filed for a preliminary injunction, and I think they have at least a chance for a preliminary injunction. And I think they have a chance because they did cover the 4 bases necessary for the preliminary injunction, but it is very hard to get. But with that said, I do think the motion for preliminary injunction makes the case overall even stronger, because if they have a strong injury case with the absence of any factual support for government action, that's going to be helpful overall. It will depend on what the government presents in support of the action, but that has yet to be seen. And what I am wondering is what this is going to equate to in relief, because it could go many ways. It could be that they are automatically off the list. They could be instructed that it's remanded to the agencies to require the agencies to provide a better explanation. So what it equates to in relief is still something I'm unsure of and mulling over. But in any event, I do also expect the government may move to dismiss on jurisdictional grounds, because the importer here bypassed, or arguably bypassed, the administrative process as it's required by regulation, that they first have merchandise excluded. They protest that exclusion under an exclusionary protest, and that denial of the exclusionary protest would get them into court. But here they bypassed that and didn't file a protest. And I think that might be fatal to the action, but again, we shall see. But you had also asked about implications, and this case is about a named entity and the process for publicly naming entities and them getting off the public UFLPA entity list, which in my experience has been a fraction of the enforcement activity going on. At least in my experience, and I'm sure Nate and Cindy could opine as well, but the vast majority of the enforcement activity CBP is doing for detention of shipments is against, or the vendors involved and the suppliers involved are not on any public list. And we're rarely seeing detentions or exclusions from entities on the public list. So the implications to me may not cross over to what most on this call are concerned with.
Nate, Cindy, any follow-up thoughts to what Amanda just said?
Yeah, I have higher hopes for the case, because just the mere listing of on the entity list itself, as Nine Star noted in its filing, that is just damning to the industry and the Forced Labor Enforcement Task Force, despite claiming they would create a process for how a company could get on or off the list. They have not published any process for that to date. That hopefully they'll continue to have standing and be able to continue on the case. But good points you raised, Amanda. But it is true that to date, the entities listed on the entity list are not the primary focus of U.S. Customs and Border Protection. The two don't seem to work in tandem, or don't work in tandem at all, actually, frankly. Is that Forced Labor Enforcement Task Force is a multi-agency entity led by the Department of Homeland Security. Customs doesn't even have a seat on the Forced Labor Enforcement Task Force, but the Forced Labor Enforcement Task Force is the one designated with adding and removing entities from the entity list. And so their process has been agonizingly slow in terms of adding entities to the list. And then again, they added 3 new entities this week, all in the apparel and footwear space, and provide no justification at all, literally no justification at all, for why they were added to the list. And so they're, again, another place where the process is clearly broken. But as Amanda said, their CBP seems to have a secret list. We've gone through this with at least 4 suppliers at this point with our members. We're all of a sudden we hear from members that multiple shipments from the same supplier, the same facility from the same supplier, has been targeted. And it takes us forever to try and figure out why this is happening, what's happening. And again, this has been happening for months, or in some cases over a year at this point, and yet these entities are still not on the entity list. And so it's happening. Something is coming up in the targeting, even, and this is yet another problem with the process, or another evidence of the broken process. Even when an importer, one of our members, has proven that the shipment has no nexus with Xinjiang, the very next shipment from that same supplier, same exact shipment, same exact supply chain, is then again detained. We've had one member, in fact, who went through this 15 times with the same exact product, same exact supplier, same exact supply chain. The previous 14 times they had gotten the shipment released because they proved to CBP that that shipment should have never been detained in the first place, and yet that 15th shipment was stopped. And regrettably, what happened in that case is that because of the huge time and expense that's involved with filing these petitions, the importer stopped working with that supplier, even though they proved time and again that that supplier should have never been targeted in the first place. It wasn't worth it anymore. But that's yet another aspect of this. But yes, there is this secret list that CBP is obviously using from targeting, which we're not sure how they're doing the targeting, that is completely divorced from the entity list.
Cindy, did you have something you wanted to add to that?
I mean, I guess the only thing is, even though CBP hasn't announced how they're doing the targeting, it is very public information, the software tools that they have access to. And so a lot of the information, I think, is coming from those tools. And the targeting is based on some of that information, as well as NGO reports, as well as, many other sources. So.
Yeah, but I would have to say that even those tools, obviously the targeting is way off, because, as evidenced by the number of detained shipments that are subsequently released. And also, even in those tools, the evidence that's being used to target can be 5 years old, 7 years old, or older. A lot can change in that time. Those relationships that these suppliers allegedly had 5 years ago no longer exist. In fact, many suppliers have gone out of their way to make sure they no longer exist. And yet the shipments are still being stopped for something that happened back in 2017, 2019, even all the way back to 2015, and some of those reports that we think are leading to these shipments being detained.
I think that's
Agreed.
It's a great point that the time dimension piece is really critical, and something we've heard over and over again from companies that have faced detentions, particularly when they are related to suppliers that maybe they are information that is old, that is outdated to some degree. And so it's absolutely a concern that's come up. Something that you mentioned that I just want to kind of emphasize here for folks, because I know this comes up as well. Just because you had a shipment released previously does not in any way guarantee that a shipment from the same supplier would not then be detained again and again and again, as Nate's example just illustrated. That is absolutely a question that has come up from some companies of, once I've had this shipment from this supplier released, or I've successfully contested a detention, am I now in the clear? That I won't face a future detention. And as we can see, that is not necessarily the case.
And even more so, it almost shows what algorithm customs is using, that you can expect if you're going to enter goods using that same algorithm of the MID and the country of origin, the HTS, you can almost expect that there might be detentions of your goods on the water.
Absolutely.
But I do want to caution on that, though, that it does seem to be, if a supplier owns multiple facilities in multiple countries, a lot of times it's focused just on one or two of those facilities. That
yes.
the shipments coming in from other facilities, even in the same country, are still entering with no problem. And again, it's hard to figure out why just this one facility or what. And in many cases, we're still trying to figure that out.
Great. Lots of really, really helpful insights shared today over the course of this panel. I'm sure for folks who are dialed in, there's a lot of follow-up questions that you may potentially have, either on this panel or any of the panels that we've discussed over the last couple of days. I would urge you to reach out to info@sourcemap.com if you do have any specific questions that weren't answered, and also to our panelists directly, if you want to follow up with them specifically on some of the points that were raised today.